Hello and welcome back to our series of video tutorials that we've been presenting over the last few months on Community Scheme Ombuds Service adjudications. Today we'll be taking a look at the matter between Errol Callaghan and the Calston Body Corporates along with the owners Theo Bentley and Derek Willie. This is an interesting adjudication as an order was made in the absence of the applicant at the adjudication proceedings. Despite being advised of the date of the adjudication, being in various correspondences with the appointed adjudicator and the CSOS, the applicant failed to attend the adjudication proceedings and failed further to contact the CSOS or to take calls from the CSOS officers relating to their non-appearance. The adjudication proceeded in the absence of the applicant and an order was made by the adjudicator. Let's take a look at this order. In the order, the applicant's points which were addressed in their application was raised and dealt with. This included the alleged encroachment onto common property by the sections owned by the two respondent owners, Theo Bentley and Derek Willie, that such encroachment was in contravention of Section 25(1) of the Constitution of the Republic of South Africa and Section 17 of the Sectional Titles Act, resulting in enrichment by these owners in the approximate amount of 500,000 rand. Therefore, the applicant sought removal of the encroachments and the repayment by the respondent owners of the applicant's costs in dealing with the issue. The respondent owners that they further wanted the respondent owners to purchase the relevant areas of common property encroached upon, and that contributions were not recovered according to participation quota as required, therefore requiring the recalculation of these contributions. It further dealt with a failure by the trustees to ensure compliance with prescribed Management Rule 68 of the Sectional Titles Act relating to harmonious appearance, and directed the respondent owners to stop claiming ownership of the encroached upon areas, further directing the respondent owners to demolish or remove the extensions and restore the common property encroached upon, directing the trustees to comply with the Sectional Titles Act, directing the appointment of an administrator or an executive managing agent, directing a special general meeting to be held to pass a unanimous resolution authorising the alienation of the common property encroached upon in terms of Section 17 of the Sectional Titles Act, directing the trustees to pay the legal costs of the applicant as well as the body corporate as respondent, and further, the disqualification of the trustees for a period of 5 years. The following points were raised by the respondent as a response to the application made and further dealt with during the adjudication proceedings. The extensions of the respondent owner sections were undertaken by previous owners. The extensions were approved by the trustees at the time. The trustees informally adjusted the contributions in accordance with the increased unregistered participation quota. During 2009, the applicant raised concerns relating to the process followed. The trustees investigated these allegations and called a special general meeting, where all the members were present or represented, and all but one abstention voted in favour of the ratification of the extensions of sections. The Surveyor General approved an amending sectional plan of extension and participation quota schedule. The applicant raised further complaints and the trustees called a further special general meeting to vote on the condonation of the extensions. Again, all the owners were present or represented and all voted in favour except for the applicant. Prior to the special general meeting, the second one that is, the applicant launched an urgent High Court application to attempt to stop the special general meeting, which application was dismissed, the applicant being ordered to pay all the related costs. The applicant failed to make payment of the costs awarded by the High Court and entered into an agreement with the body corporate to withdraw any objections to the extensions on condition that the body corporate did not pursue its claim for costs, as awarded by the High Court. This agreement was entered into and the extensions were then registered. In dealing with the applicant's points as well as the response by the respondents, the adjudicator set out the following points in his adjudication order. As the extensions of the sections had been undertaken as allowed under the Sectional Titles Act, there was no basis to conclude that there was unlawful or arbitrary deprivation of property. A unanimous resolution was not required under Section 17 of the Sectional Titles Act, and the processes under both Section 24 of the Sectional Titles Act and Section 5 of the Sectional Title Schemes Management Act was followed by the applicant owners as required. The allegation of enrichment was unfounded, and it was further found that there is no requirement under the Sectional Titles Act or the Sectional Title Schemes Management Act for any amount of compensation to be paid to the body corporate by the applicant owners. It was found that the contributions levied were not incorrectly determined or unreasonable, as the adjustments to contributions levied had taken place at the time of the extensions and not only when legally required, which would be at the registration of these extensions. The application for the appointment of an administrator was not entertained, as it fell outside of the jurisdiction of the CSOS. The adjudicator noted that the managing agent had terminated their services to the body corporate due to the conduct of the applicant. It was found that there is no basis for disqualifying the trustees, and that such disqualification, in any event, fell outside the scope of what could be determined by the CSOS. It was further found that there was no evidence that the trustees acted in contravention of their fiduciary duty to the body corporate. Therefore, in summary, the adjudicator's order found that the relief sought by the applicant was misconceived and without substance, and was therefore dismissed. A cost order was made against the applicant and the co-owners of the applicant's unit. I hope you enjoyed this video. Until next time.